Oh, this is a great question, and it's really pretty hard because it's new. It just was issued on February 14th, Valentine's Day.
Uh-oh.
USCIS issued, USCIS, it's a U.S. Citizenship and Immigration Services in the U.S.
Mm-hmm.
issued policy guidance with regards to how to calculate Child Status Protection Act age. And we were waiting for this. There was a lot of confusion. CSPA was enacted in 2001, so that's fine. However, in 2015, the confusion started. Why? Department of State started issuing visa bulletin with two different charts, two for family-based cases, two for employment-based cases. One is a final day chart, final action day chart, and one is filing day chart. So what does it mean for USCIS, for people filing within the United States adjustment of status? Each month, so once Department of State issues visa bulletin with the two charts, then USCIS will determine which chart they're going to be using for the purposes of filing an adjustment of status within the United States. So we always wait after the visa bulletin is issued to see what we are going to do. In 2018, USCIS determined that they're going to be using, for the purposes of Child Status Protection Act, only final action date chart. And that created a lot of problems because there were some applicants filing adjustment of status based on the filing date, especially around 2020. There were a lot of cases, and we've had these discussions with clients that we filed for these kids, but we were not sure if in the future they're going to benefit from it because, as I mentioned, they were using final action date chart for the purposes of the calculation. So finally now, the government decided and they issued in as a policy guidance that they're going to be using either one. So if USCIS for that particular month is using final action date, they're going to be using final action date chart for the purposes of CSPA calculation. However, if they're using, like they're using, for example, for this month and next month, they're using filing date chart, they're going to be using that chart for the purposes of CSPA calculation. What does it really mean? Because I keep explaining. So what it really means, it's going to, once adjustment of status is filed, it's going to freeze the age. So there is no more concern that, later on the child will age out. So it will freeze the child's age, assuming that the CSPA calculation works. Of course, there are some cases that were maybe denied in the past few years. So there is an option to file motion to reopen. As we know, usually the motions have to be filed within 30 days. We do have some flexibility for COVID, but still we have a non-protunct type of late filing where USCIS in their discretion can excuse the untimely filing of the motion. So that's something to consider. And for those that have cases denied for the kids because of that issue, they should really consider and, maybe file motion to reopen. So it's a really welcome news. I'm sure it's going to help a lot of kids or those, aging out. So we're really excited about it.
Yes, it must be a great relief for folks in that predicament. And thank you so much for clarifying and bringing this to light for us. So whether you need a green card, employment verification assistance, or help with Canadian immigration, you can always rely on the NPZ Law Group. Call them today at 201-670